As Indian judiciary goes through some of its most turbulent times, in conversation with us is Justice Chelameswar, the man who took up the cajoles against Justice Deepak Mishra, went public all those months back. Perhaps some of what he said holds true to date. Thank you very much for joining us, sir. And I think many people will say, were you a judge with a cause? Are you a rebel judge? Are you simply a straightforward person who saw the rot in the system and put it out? Now that you've hung up your boots in the court, how best would you describe yourself with your stint at India's apex institution?
Describe myself. Describe myself as a humble citizen of this country today.
A humble citizen of the country who decided to speak when it was
Of course,
required?
citizens are entitled to speak. That's what the Constitution guarantees in this country.
The reason why I asked you that question, sir, and I know, I'll come to NJC in just a bit because you, from being a lone dissenter and all of that. Justice Kurian, who retired a few days back, said that what was happening in the court was, there was a sense that things were being controlled from the outside, and which is why that unprecedented press conference and all of that. In hindsight, were matters worse than you were seeing? Have things improved at all?
I can't say they have improved, but there's certainly some change. I can't say it is totally changed and improved absolutely, but certainly a beginning was made. That's what I believe.
When you say a beginning was made, what else needs to be done? And I'm presuming that, 4 of the senior most judges of the Supreme Court went public, spoke to the media because you realized that there were perhaps no other alternatives. What else needs to be done to preserve and protect the independence of the judiciary?
More rational procedures both in the administration of the judicial system and also the selection process, the transfers, and the manner in which the authority of the Chief Justice of India as master of the roster is used. All these things require more rational and transparent processes.
But as master of the roster, I'm presuming there is some amount of discretion that comes with the job.
Nobody disputed it. Did we ever dispute it? We always. But question is that see, when it comes to the administrative authority, the Supreme Court has lectured time and again, wrote acres and acres of judgment saying that every aspect of the governance must be informed with reason and rationality. Would it not apply to the judicial institution? Master of the roster, yes, nobody disputes. It's a matter of convenience. But on what principles are you doing these things? Some discernible principle.
Fair point indeed. But is there merit in the argument and the concern that's voiced from time and again, the politics of the day that kind of gets involved in from judicial appointments to sometimes people taking a back seat on judgments to sometimes delaying judgments, and of course appointments is the big bone of contention, and I'll come to NJC next. But is the politics of the day undeniable in judiciary?
Always, not today. Always, everywhere, not only in this country, every country it happens. Question is how alert and how conscious the citizenry is, the institutions are, how prepared the institutions are to meet these pulls and pushes, and how true they are to the values of the Constitution. That's what matters. But they always happen.
So I agree with you, and that's perhaps the reality. The pulls and pressures are the reality. But when you went public and when you voiced concerns, do you believe the court had become lax, less alert of political interference?
We believed so. Question is not, even there must have been phases, there were phases in the history of this democracy earlier also, where certain things happened. But then it was for the incumbents of the day to have taken corrective measures. What steps they took or did not take, and I don't want to go into all this history now, this thing. But at least when we were there, and we have taken an oath to uphold the Constitution, we tried our own best to correct the thing. And having realized that there is no way we can achieve the target, we thought best thing is to inform the nation.
But do you think things changed after you informed the country and went public with it?
Well, I can't say things changed completely, but there is some alertness, there is a debate, people talk about it, and some amount of public opinion, and which acts as a great pressure on anybody holding a public office. Public opinion does make some difference. I think suddenly that public opinion is created.
There is a question that I want to ask you, sir, and I think it was written in editorials, and I'm sure you received as many bouquets as brickbats that you got after this.
More brickbats.
More brickbats. But I think
weighty brickbats from great people.
Who are the great people you're
Well,
referring to?
that is irrelevant. But
But
then
when you say-
a lot of small people supported me.
Fair point, which is exactly my question, that when small people support you, it's because the small people in this country believe the judiciary is the last port of call, and
Yes,
Supreme Court is the
it
last
is- it
bastion
is-
to defend our rights, our
In
constitution,
theory, that is the
and all of that. Do you believe going public in some sense would have eroded that faith, or do you believe it strengthened it
Ma'am,
further?
my answer is this. There was an impeachment motion against Nixon. The man walked out of the office, unable to take the pressure. Is the presidency of America any less important after that? It doesn't depend upon what happens to this. On the other hand, when ultimately the respect for an institution depends upon the democratic utility of the institution. If things go wrong or going wrong, if they are going wrong, by concealing them, you are not enhancing the prestige or glory of the institution. Only by correcting the errors, you will strengthen the institution. That's what I believe, at least. If some people believe dust everything under the carpet, people, well, I have my own doubts. They may not talk in front of you, but outside what they talk, we know. At least I know.
There is a reason why they say sunlight is the best disinfectant.
Yes, it is.
One more criticism that has been leveled against the judiciary time and again and through various orders is that, are you stepping into what is really the executive's domain, whether it's the Aadhaar judgment and all of that? I'll talk about the specific judgment, but are you really stepping, are the courts really overstepping and breaching what they call balance of power?
Which judgment you are referring to. If you're specific.
Let me begin with Aadhaar. The courts obviously in their rights mind said that it is, the government wanted it mandatory, the court said it should not be made mandatory. The government of the day believes that perhaps the courts stepped on to what is really the executive domain.
I don't think that is an appropriate example, because what was decided in Aadhaar, the first round question was whether a citizen has a fundamental right of privacy.
That's right, yes.
So the 9-judge bench held, yes, there is a fundamental right of privacy. Now, whether the particular Aadhaar scheme in any way tramples upon that fundamental right is a different examination altogether. Now, what way did the Supreme Court overstep the executive domain? The Constitution authorizes the Supreme Court to examine every action of the legislature and the executive, barring policy matters. Even that policy matters also is a self-imposed restraint, but is a time-honored principle.
That's right. Yes.
Right. We don't enter policy matters. Some things like international relations. And these are the things beyond which for the elected people to decide these things. But within, subject to these exceptions, every action of the Parliament, including the Parliament's authority to amend the Constitution, is subject to judicial review. No, unless you give a more concrete example, look here, this is an area where the court ought not to have intervened. General accusations, of course, comfortably they make.
No, I agree with you, and which is why, so you don't believe there is any judicial overreach that's happening, and those accusations are...
I'm not saying that it never happened. There could be instances here and there. But question is, please, that's what I'm saying, please point out a specific judgment. Look here, do you think it is right or wrong? Maybe I'll have an
So
opinion.
on Aadhaar, you don't think there was a big breach of executive domain? The reason why, sir, I also ask you that question is that increasingly there is this tendency to pass the buck to the courts when it comes to controversial issues, where politicians don't want to take a call. They're ambivalent on it because there's a vote bank to cater to, whether it was 377 or Aadhaar or the Ram Temple or the Triple Talaq. In some sense, the courts then are the last bastion and the politicians don't want to take a call, and suddenly when it comes to executive domain, they're a little touchy. What would you say about the double speak, so to say?
Because politicians as a class are very intelligent, therefore they know how to play the game. Maybe my own brethren are not that intelligent in this sense, apart from their learning of law. Maybe they are not strategicians like this to understand all these things. Sometimes perhaps they walk into the trap.
But what should the courts then do? Because these are issues that determine that are of national importance, and these determine the lives and the way we live. And if the politicians refuse to take a call,
See, ma'am,
are courts the last hope?
The question is this. See, essentially, yes, when you are talking about judicial overreach, let us, at least my view is that the courts do not undertake the responsibility of governing this country. Lot of decisions which are to be taken by people who are elected, because they will be answerable if I take it. See, this is exactly, it was a controversial judgment. Quite a lot of people criticize me for that Rajbala judgment.
That's right.
Now, question is whether it is the right value, whether we should impose a limitation of an educational qualification on somebody who is seeking to become a Panchayat board member or not, is a value judgment. It's not for me. It's not for, as an institution, it's not for the judiciary to make that value judgment, unless there is something which is directly in conflict with the constitutional mandate. It's a value judgment which the assembly made. Now, if people are not happy with that value judgment, it's open for the people next time to throw out that party which made that law. Now, if a judge starts deciding it, because the judge is not answerable to anybody in these matters. So, therefore, those areas judiciary should not enter is my opinion. Well, and how it gets translated into in concrete instances is a different matter.
But then what happens to an issue where policymakers are not going to decide because they are obviously being opportunists and the judiciary doesn't want to enter because...
Well, what do we do? It's for the people. See, remember, please don't come to mistake. You and I are not the only citizens of this country. If the majority of the people in this country, out of ignorance or even knowingly, are happy with that state of affairs, we can't change the thing by ourselves. The maximum we can do is try to inform the people, the citizenry, look here, this is not good for you. Convince them. Let them take a wise decision. But you can't impose a decision. Then in which case, what is the difference between a dictatorship and this?
So then are you saying
you have a good, well-meaning dictator, he'll take the right decisions. He is not elected, he is not answerable to anybody. Will you be happy with that?
No,
let us change this system of governance then.
No, but then are you here suggesting that the court should not have made a judgment on some of the issues that they did because these were issues of policy domain?
Some of them, yes.
The reason why, sir, I also asked that question is, and I know you have your reservations on speaking on matters that are still sub judice. Rafale is a big controversy.
I told you the matter is still sub judice. I believe there is something pending in the court,
yes.
So I don't want to comment.
I know you don't want to comment specifically on that, but there is this new trend, a new way of verdict delivery and judgment delivery that we are seeing, which is the practice of sealed cover. Now, ours is an adversarial judicial system where litigants go head on against each other. Does this sealed cover practice not undermine our judicial system, because sometimes the respondent and sometimes the petitioner doesn't really get the opportunity to
see? A sealed cover practice or an in-camera proceeding is not the norm. The Supreme Court way back in Mirazgar's case said, in fact, I don't know whether you were there yesterday in my Vidhi, this thing. I opened my speech with the quote from Bentham, which was quoted with approval by the Supreme Court, a constitutional bench of this court. Now, it's not the norm and it's not the right thing. Now, but the law itself recognizes exceptional situations where certain information is to be protected. But what are those what are those cases where the principle is rightly invoked, and what are those cases? It's a matter of individual analysis of each case. But if it becomes a norm, certainly it is not right.
But do you believe increasingly it's being resorted to? I mean, in a case as big as this, which is being watched by everybody, this is a major case that's going on, you have a sealed cover practice, and look at the fallout of that, whether it's grammatically incorrect or factually incorrect.
Well, perhaps if I were to be there, I wouldn't have done it. That's all I can say. I wouldn't have resorted to this sealed cover procedure.
Without getting into the domain of this case, sir, there have been instances, and even in this particular case, the court has opined several times in its order that it is not in its jurisdiction or domain, and it has yet passed a judgment.
I'm not going to comment about that case. I told you the matter is still somewhere still lingering around the court, the sub judice. I don't want to comment further about it. Since the other question is a much larger question, not confined to one particular
Sure enough.
case, I answer.
Yes, but is there, as a judge, I want to know, and there is a lot of divided legal opinion on this, as a former Supreme Court judge and one of the senior most judges, is there preview of correcting a judgment which is, and I'm not really referring to Rafale here, can a judgment be corrected barring some typos or some, clerkier errors? This is a factual error.
No, one second. See, judgment can be correct. This is once again without reference
Sure,
to
yeah, I
this
understand.
thing.
I understand.
The principle is any judgment can be corrected. There are ways and procedures by which judgments could be. An erroneous judgment could always be corrected. Say, for example, when you prefer an appeal, what is it that the appellate court is doing? It's correcting a judgment.
That's
Suppose
right.
if it's interfering
Yes.
with the judgment of the lower court, it's a correction mechanism. Now, depending upon the situation, there are always ultimate purpose is to secure justice.
True.
If there is an erroneous judgment for whatever reason, either the mistake of the parties, mistake of the court, or whatever is the reason, if the judgment is demonstrated to be erroneous, courts have always held the opinion that what is more important is maintaining the purity of the stream of justice, not the technicalities. Judgments can always be corrected. What is the appropriate procedure depends upon the forum which is seeking to correct, the forum from which committed the error, and the procedure that is sought to be followed in correcting the error. They are all different matters.
A quick last question, sir. From being the lone dissenter when the NGSE system was rejected in favor of a collegium, we seem to have come a long way, not to the satisfaction almost all the time. How do things evolve from here? What needs to be done to make this more transparent, to make this a system where faith doesn't get eroded?
See, that's what I've been saying for the last 2 years. All right, we accept the finality of NGSE for the time being until, but there's no guarantee that no judgment is eternal.
True.
Maybe in 20 years or 15 or 10 years later, although the judgment might be reviewed. We don't know, but it's possible in theory. Point is this: if it is final for the time being, all right, make the system more transparent. The power is with the collegium. Let the collegium proceedings be more transparent. Let the proceedings be recorded. Let the views be recorded.
Thank you very much for speaking to us, sir.